Welcome to Power of Attorney. I am your host, LaTanya Moore, and today I'm very excited. Listen, before we jump right into our topic, I have some exciting news to share with all of you. I am pleased to announce that on February 1st, we will be launching our intellectual property and transaction program for small disadvantaged business owners. Now, this program has been a little bit more than 1 year in the making, and so I'm very excited because it's finally a reality. So, what is this program? It actually provides trademark and copyright assistance. So we provide counseling, registration support, application prep, and filing, along with any type of entity formation, organizing documents like LLCs. We're going to be working with nonprofits, helping them with their transactional work. So very, very, very excited. Now, we will not be prosecuting patents or any type of trademark infringement or trademark enforcement, none of those as part of this program. But this program really makes basic brand protection a reality for small disadvantaged business owners. So kudos to us. We are going to be accepting probably about 30 applicants. Well, let me say this, 30 program participants. We will be accepting applications from February 1st until June 30th, or until the total number of slots are filled. We only have room for 30 slots. But what's a small disadvantaged business? Because I know that's what all of you guys are asking. Am I eligible? Am I eligible? Now, we are going to be following certain income and need-based guidelines, of course. Verification will be required if you are applying from a needs-based standpoint. We are going to be looking at younger businesses, right, that are newer versus older. So we have a matrix that our intake personnel will be looking at while going through the application process. Of course, our goal is to assist as many people that lack the means to obtain counsel on their own. And so these services are offered at a steeply discounted rate, again, based on our internal needs assessment procedures. Now, note, you will be responsible for paying any filing fees. So you want to make sure that you check to see what those filing fee amounts are before you get into the program. Because what we don't want is for you to have all of this work done and then you're not positioned to be able to afford those filing fees. So we want to make sure that, guys, we have those. There is an admin fee. Of course, that just covers the cost of our personnel who will have to go through this process with you guys. So if you believe that you fit that strict criteria and wish to submit a request for representation, again, it is just a request. You are not a client. There is no obligation until you are accepted and you have a signed engagement letter. So I want to make that clear. This will be a request for consideration, and we will be administering the application process. So if you or someone that you know qualifies as a small disadvantaged business owner based on what we just shared, reach out to IP@iprotectyourbrand.com. Make sure that you put IP program in the subject line because we want to make sure that you are routed to the right person. So thank you guys again. That's IP@iprotectyourbrand.com. For those of you that want to apply, I would suggest applying sooner rather than later. When you reach out, you will be sent a link to turning in your information and to schedule your appointment for your assessment. So thank you guys for indulging me during that process. So again, I am LaTanya Moore, your host, and today on Power of Attorney, we will be discussing who owns the copyright. We get this all the time, right? Because see, oftentimes there's a question or confusion over who the rightful owner of a copyright in a creative product is. And so in my practice, I see this a couple of ways. So first, Someone commissions a provider to create a product they've conceived. So, they see this thing in a dream. I don't know, God told them, and they want to make it a reality. So they find someone who can create whatever this thing is. So the second scenario that we see is that sometimes there's an employee of a company that creates a product, and the product, of course, is something that they've created within the scope of their employment. So what happens then? So those are the two major scenarios where we see there's typically a question of, okay, who's the rightful owner? Who has the rights, or who can claim the property rights in whatever this thing is? And so we have to ask ourselves, like, who's even eligible to be an owner, right? And so in general, it's whoever the author or creator of the work is, who did this initially. So when we're talking about, let's say, a book, for example, or a workbook or a curriculum, because we see that in general, the general rule is that whoever creates that product, they are indeed the copyright owner. But when we're talking about a corporate entity, for example, which means that this particular person in the employee context, they created this curriculum for use as part of their job, right? So then what happens? Typically, when you are working for a company, there is something in the company policy, procedure, handbook. Trust me, there is something that more than likely you have signed that said that the company is actually the copyright owner, and that anything that you develop within the scope of your employment, those are the key phrases, within the scope of your duties, within the scope of your job, that is actually owned by the company. Now, you guys can do your own research on how that goes down, and you'll see lots of times where people say, well, this was on my own personal time and it has nothing to do with the job. I never used it in the scope of my work, but that's not always a winner. It really isn't. So you really have to think about that, because when we're dealing with employers, right, the question really comes down is, was this a work for hire situation, right? Were you hired to create this particular work? So a work will be considered a work made for hire if, again, it was prepared within the scope of your employment. Now, common law says that if you are working for a company and something happens, right? That's just like if you do something negligent, the company may be liable for your negligence because you are acting within the scope of your employment. It happens the same when we're looking at copyrights, okay? We're looking at, was this in the scope of your employment? Is this something that you were hired to do, okay? So what happens though when it's a work for hire, but it's not an employee, and let's say it's an independent contractor that's doing something else? See, now you have to make sure that you are very clear that this is a specific work made for hire, even though this person is not your employee. If you are creating something for someone else and you want to, and they want you to give up the copyrights or any type of intellectual property rights, you need to really think about that in your pricing. Or you have to decide if you're going to retain the copyrights, because the intellectual property rights, because you want to make sure that that is actually included in your agreement. Okay? Because here's the thing. If it is prepared, let's say you're an independent contractor, is prepared for a work made for hire, guess what? The person who hires you is really considered to be the owner, the author of the work. And so in order for you to retain those rights, you need to agree that, you know what I'm saying? You need to agree that you are giving up those rights. You need to agree that there was a specific commission or something that was provided to you so that it is very clear on the scope. Now, oftentimes people work together, they create projects together. Of course, you can always have co-owners, co-intellectual property owners and things of that nature. But again, in those type of agreements, you really also need to make sure that you're clear on what the percentage of ownership is if it's less than 50-50. Now, intellectual property rights are like any other property rights. That means that they can be transferred, they can be licensed, they can be mortgaged if they're valuable, right? So I won't waste your time talking about a whole lot of different statutory provisions and things of that nature. But the things that you need to know is that there are different levels of licensing. And that's really what you have to really know about. There are different levels of licensing. Sometimes in our own actions, we can create a situation where we almost have given exclusive rights to our intellectual property just out of the way that we operate. And so you want to make sure that you're very, very careful in doing that. You can also terminate rights. Okay, if you transfer those rights, if you provide a license, if you provide some type of transfer, you have a mortgage and so on and so forth. Some of those things, some of the cancellation or termination of rights are based on whether, you've paid off the debt and things like that, if it's a mortgage. But also, you also want to make sure that there is not an open-ended perpetual time frame that you are allowing for a license, for example. So very, very, very important. But here's the big thing. In 2019, there were lots of changes and requirements to when you have standing to bring a copyright claim, when you can, even if you bring the claim and you're allowed to bring the claim, when you can actually benefit if you win, right? So you have to think about that. So the biggest requirement is that you must file and record with the Copyright Office, because recording in the Copyright Office, it gives everybody in the world, right? Well, everybody that's looking at the United States, for example, it gives everyone constructive notice that the work has been registered. If there is a transfer, you may record that as well, but you have to make sure that you follow all of the proper policies and procedures for doing that, and make sure that it is very, very well documented. What I would suggest is some type of sworn notarized statement, making sure that all I's are dotted, T's are crossed, because you want to, again, make sure that everyone is on actual or constructive notice that there has been a transfer or a change, or even that there's been a formal registration of the copywritten material. So again, thank you guys so much for tuning in to Power of Attorney podcast. I want to invite you to like our Facebook page, Power of Attorney with LaTanya Moore. Make sure that you subscribe to our podcast on Spreaker, Apple Podcast, Google Podcast, iHeartRadio, Stitcher, Spotify, YouTube, Amazon Fire TV, and more. You can also connect with me directly at the website. It is iprotectyourbrand.com. And so until next time, I'm Attorney LaTanya Moore, encouraging you to leverage your power and protect your brand.